Good afternoon, everybody. My name is Alexander Rufus-Isaacs, and I am the chair of this afternoon's program. I would like to welcome you all to this Zoom presentation of the Beverly Hills Bar Association. I see the list of very distinguished participants we have today. I'd like to welcome you all and also assure you that we cannot see you. So if you are, shall we say, informally attired or not your usual impeccable cloth self, don't worry, you can relax. Nobody can see you. It will only be Pierce and myself up on the program visually. This is a program being put on by the litigation section of the Beverly Hills Bar, which has been around for a while, but under our new chair, Brian Bergman, we're becoming a lot more active. Our next program is on June 11th about enforcing and busting arbitration agreements. Our panelists are Neville Johnson, Adam Wolfson, with Rudy Lara moderating, and that's in association with the entertainment law section. Today's program is entitled War Stories, and it really goes back to my early days when I started as a barrister in London, and one of my jobs as a young pupil barrister was to escort the more distinguished, shall we say, members of chambers to a wine bar on Fleet Street called Elvino's. And there I would basically sit at the feet of the masters and be plied with drinks and listen to this endless connection of stories, which really in many ways encompass what I would call the folklore of the English bar. And it was one of the things I enjoyed most about it, and I think was one of the real bonding issues. Over here, obviously, we aren't in the same geographical area, but nevertheless, I thought that all of our programs are normally aimed at recent developments in X, Y, and Z, or cutting edge issues in A, B, and C, and that it might be good to take a look back at our folklore and give an opportunity to some of our more legendary trial lawyers to talk about some of the landmark cases in which they've been involved. And I could think of no more fitting person to kick this off than Pierce O'Donnell, who's been a hero of mine for many years. I was very gratified to be able to work with him in 1998, and I've always held him in the absolute highest esteem. I join in what Dick Trevisan, one of our former federal judges, said of Pierce, which he said, "I've known Pierce for 35 years. I've seen him perform in the most complex, challenging cases. Pierce is a man of impeccable integrity with a passion for justice, and I wholeheartedly support that. He's also a great entertainer and a great lawyer. He started his career at Georgetown, where incidentally he also was on the football team, Georgetown law, Yale law, Byron White on the U.S. Supreme Court, Shirley Hofstetler on the Ninth Circuit, and he trained with Edward Bennett Williams. Since then, he's gone on to scale peak after peak in the law. As well as the case we're going to be talking about today, he has represented numerous people, including Faye Dunaway, James Bond Company, and he's recovered over $5 billion for his various clients. In addition to that, Pierce has written over 200 articles and books, including one which I'm going to plump to you today. It's entitled Fatal Subtraction, and it's the story of the Buchwald trial, so I highly recommend it. Pierce even wrote a screenplay, including Steve Guttenberg's movie Home Team. So with all of that said, I'm going to kick it over to Pierce in a minute. He's going to go till 1:15, and at 1:15 we're going to start question and answers. If you have any questions you would like me to put to Pierce, please use the Q&A function at the bottom of your screen, and I will read them, and then I will put the what I believe most pertinent questions to Pierce, and we're going to wrap up at 1:30. So again, thank you all very much for joining, and with no further ado, I will hand over to Pierce O'Donnell, who's going to talk about war stories.
Thank you, Sam. It's a privilege to inaugurate this. I think it's going to be a great series. I'm not going to take too long because we all want to get back to our Mork and Mindy reruns, and the El Pollo Loco guy is coming at 1:30, so I got to be done by 1:30. Buchwald versus Paramount Pictures was initially a third-rate contract case, if you remember Watergate. Art Buchwald was the most illustrious humorist in America. In the late 1980s, he had 650 newspaper columns around the world. He had won the prestigious Mark Twain Award, which goes to very few humorists, named after great Mark Twain. But he had flirted around with Hollywood. He knew people in Hollywood. He'd come out here every now and then and hang around with various folks in the Hollywood scene. And he had a good friend, Alan Bernheim, who had been a very distinguished talent agent and literary agent in Paris and moved to California and Los Angeles about 10 years before the case. And they were good friends. Hollywood is always in search of a good idea and good ideas that can be executed as blockbusters. And in the mid-1980s, Paramount Pictures had on its hand an incredible star named Eddie Murphy. And he was skyrocketing, Trading Places, all the movies he had done. And they were looking for a new star vehicle for Eddie Murphy. Along came Art Buchwald. Art Buchwald wrote an 8-page treatment called It's a Crude, Crude World. It was about a young African prince who comes from an African country, comes to America. He's deposed, ends up in the ghetto, has adventures, falls in love, and lives happily ever after. He condensed it to a 2.5-page treatment retitled King for a Day. Paramount was very excited about it, and they optioned it. And we know in our business, it's sort of like leasing it, like leasing a story. And attached to it was Bernheim, and they both had contracts with Paramount. The contract was pretty typical. It had a basic provision that for fixed compensation, not a lot. Well, back up. First, the option was $25,000. It was renewed several times. Bernheim didn't get any money up front. Bernheim's contract provided for 17.5% of the net profits and I think a couple $100,000 fixed compensation. And Buchwald's contract provided for these $25,000 options, I think 50 grand if they actually bought the story, and they buy the story when they've decided to proceed with the movie. Buchwald had 1.5% of net profits. So together, the producer, creator team had 19% of the net profits, okay? The contract said, if we make a movie based upon your story, King for a Day, good things will happen. Bernheim will be hired as a producer, and you will get this fixed compensation, modest as it is, and the two of you will get 19% of the net profits as defined in the contract. And the definition was a standard rider that Paramount attached, and as the judge found, the clauses, the net profit terms and definitions were essentially the same. So Buchwald's story ends up at Paramount. Jeff Katzenberg is there, Ned Tannen, and they develop it. They do 2 scripts. Murphy reads them, and Murphy decides, for whatever reason, he's not going to do it. Eisner, Katzenberg, all those guys go over the hill to Disney, and the project looks dead. Bernheim takes the story to Warner Brothers. They option it. They're going to make a movie until it's announced in early 1988 that Paramount has a new Eddie Murphy star vehicle coming out in the summer called Coming to America. When Bernheim saw the storyline, he got a little suspicious. The movie came out, and Bernheim calls Buchwald, who's on Martha's Vineyard summering, as he did every year, with his friends Bill Steyer and Mike Wallace and others. He said, Art, you better go see this movie. So Art goes to the tiny Capawack Theater in Vineyard Haven, and he sees the movie, and he's pissed. He walks out, goes to his house, landline, calls Alan, he says, I've seen the movie. Let's hire a lawyer. I had worked for the legendary lawyer Ever Bennett Williams when I was in law school, and for 3 years after my clerkships, and I met this guy named Art Buchwald. He was the umpire of softball games between law firms like Arnold, Porter, Williams, and Conley. and he was blind, couldn't see. He was the worst umpire he ever met. But I just met him. And I represented a guy named Danny Arnold who created the Barney Miller series and other things. And he was close friends with Bernheim. And Danny said, there's this young Irish kid, maybe you might want to interview him. I went to New Orleans because my wife lived there, and Buchwald was there for the 1988 Republican National Convention. And we met in a darkened room at a hotel because Edward Bennett Williams had just died. Buchwald's best friend and my mentor. It was a sad afternoon. We got down to business, and I said, Art, I've read your story, I've seen the movie, and I've read your contract. And you don't have a copyright infringement case. And he kind of got long and looked at me because he's a writer. He knew what copyright was. I said, no, but you might have a breach of contract case. And I told him about the clause in the contract that if we make a movie based upon your idea, we got to pay you a lot of money. We're obligated to you. And I said, I read this contract twice. And then on the flight down here, I read it a third time. And sometimes when you read something the third time, you see it. And that's when I discovered the based upon language. I had my colleagues back at my firm research it. We didn't have legal research online. And they found some cases that had construed based upon in a contractual setting. I explained to Art what that law was, that it didn't have to be a slavish copying. You didn't have to meet all the rigors of a copyright case. But if they used your idea in any material way, if it was the starting point or the beginning of a creative process, you might have a case. And Art said, look, I want to go after these bastards. And I said, well, I think I can get my firm to take this on a contingency. I just opened the LA office for Kay Scholler in 1988, and this looked like a pretty good case. He said, but I want to tell you one thing. I don't want to look like I'm suing Eddie Murphy. They gave him a story credit, and he's the star. And I'm a white Jew, old white Jew, and he's a fantastic, popular black actor, comedian. And I don't want that. If it's ever going to become that, I don't want to do this. I assured him that I would do my best to see that that didn't happen, and it really never did happen. In fact, the judge, if you've read his first opinion, of the three opinions, went out of his way to say that this was not no aspersions were being casted on Eddie Murphy, that he and Buchwald were both national treasures, et cetera, et cetera, et cetera. So I was visiting with a good friend of mine, Ron Silverman, then a lawyer, now he's a rich banker. And I told him about the case. I said, I think I'm going to take it. He said, oh, Pierce, come on. Such a thin comparison. I mean, you bring that case, you're on a frolic and a detour. And every time I see Ron, I say, hey, frolic and a detour. So we filed the complaint, and it ended up on the front page of the Wall Street Journal, the New York Times, et cetera, et cetera. For some reason, the media and Hollywood were very interested in this battle. A writer up against a studio over creative rights. And I'm going to summarize this a little bit because I want to get into some of this war story part. Anyway, we filed a complaint. Demurrer was overruled, and by a judge named Harvey Schneider. He was a kind of an enigma. Nobody knew much about him. Been to UCLA Law School, very smart, been a U.S. federal magistrate. And so the first war story, and may have been the most significant one that we made, I had two young associates and maybe a 35-ish partner, all women, lawyers, and a very wonderful guy named Dennis Landry, my paralegal. And so we had to decide whether we wanted a jury trial. Of course, we were entitled to one, and we pled for a jury trial. And I thought about it. I said, they say Eddie Murphy created this. They gave him the story credit. Imagine Eddie Murphy testifying in a courtroom downtown LA before a LA jury that you get in downtown. It wasn't called the Moss Courthouse, but it's what we call the Moss Courthouse today. I said, Eddie Murphy could levitate a jury, and we could never win. Because, you know, my experience in Hollywood is stars always win these kinds of battles. And so how do I pull this off? So we had a status conference a couple of months before the trial. And I said, you know, Your Honor, you know, Paramount doesn't think much of this case, and they think it can be tried in a day or two. And it probably might come down to kind of a pretty straight up legal question. Mr. Buchwald, Mr. Bernheim would be willing to waive a jury if Paramount would. Okay, well, hold my breath. And Robert Draper, the then O'Melveny partner on charge of the defense, said, yeah, this is not going to take much time, Your Honor. We'll waive a jury. That was the beginning of 3 trials. Buchwald 1, Buchwald 2, and Buchwald 3. A new thing called Court TV with a guy named Harvey Levin had just been launched, and they televised the first and the third trials. A ton of pretrial discovery was done, and the trial began in 1989. It lasted several weeks, and the trial focused upon the creative process. What did they do with Buchwald's script? We had gotten tens of thousands of pages of evidence. I'm not sure this is a war story, but the devil's in the details. And we had combed through every page, every paragraph, and there were nuggets in many, many of these documents. A trial lawyer is an artist. He or she paints, and often it's just a mosaic or an impression. And we put in all of this evidence. Mr. Draper times it, that's not relevant here or wherever. It all became quite clear what the purpose of all that evidence was in the closing arguments. I don't think I've ever prepared in my life before or after more for a closing argument. One thing I knew was Judge Harvey Friedman was a hot bench. He would ask questions, and he asked withering questions of both sides. Buchwald had testified. Paramount had raised an argument that had really upset and actually depressed a guy who already had depression, Art Buchwald. They alleged that Buchwald had plagiarized a 1950s Charlie Chaplin movie called King for a Day, which was the title of Buchwald's treatment. Buchwald was very, very upset. So much so I think he was regretting having brought the case. He had an unsullied record as a journalist, never even a hint or whiff of impropriety or plagiarism. He was very upset. He was in LA the night before the closing argument, and I sat him down knowing he was upset. Art, I'll make you one promise. We may or may not win this case, but I'm going to tell you one thing. There's no way in hell that this judge of the world is going to think that you filched an old Charlie Chaplin movie to come up with your treatment. And I went out of my way in the closing argument to press that point with the judge, and bless him, he's a good man, decent man. He went out of his way in the opinion to make an express finding that Buchwald had not plagiarized or borrowed or copied anything in the old Charlie Chaplin movie. The issue of based upon was not unique in Hollywood. There were some prior contract cases, but its application in this case was rather unusual. The defense was independent creation. We all know that. Eddie Murphy created this. Except it can't be independent if the alleged independent creator was exposed to the plaintiff's story or treatment. And I was able to prove through documents, through Murphy's own testimony, that he had been exposed. He and his manager were aware of the Buchwald story. In closing argument, the judge said, Mr. O'Donnell, would you agree with me that there could have been circumstances, or there can be, under which Mr. Murphy independently created this movie? Not like I wasn't prepared for that question. We had done a lot of mock argument work before the closing argument. I said, well, sure, Your Honor. I think that there could be a circumstance. For example, Mr. Murphy could have decided to go live in an igloo right at the North Pole with no communications. He was shut off from the world for a year, and they can prove that. They would have established, and I would lose, they would have established independent creation. Now, any good trial lawyer has that but ready right on the tip of her tongue. But, Your Honor, that's not what happened here. It gave me a chance for a 5-minute riff about all the evidence of exposure, going back to the similarities. And the judge invoked an important rule that many of you know about in this intellectual property field called the inverse ratio rule. The greater the exposure, the less similarity you have to show. And we had beaucoup exposure. There was no dispute about exposure. So Mr. Draper made a series of arguments about why it was there was no substantial similarity. And I didn't understand that argument because this was not a copyright case. This wasn't a plagiarism case. This was a breach of contract, a misappropriation of an idea in violation of a contract. And he kept infusing, plot, theme, character, and so I knew that would probably happen, but it doesn't seem to me it was resonating with the judge. So in my rebuttal, I had an opportunity to attack. And I said, well, it's not a copyright case, but boy, look at all the similarities. Look how this idea evolved through multiple, 2 scripts and multiple comments by creative executives at the studio. Look what Jeff Katzenberg wrote. Look what so-and-so wrote. And it gave me an opportunity to tell the judge, look, you can be comfortable here. It's okay. Because even though the dissimilarities far outweighed the similarities, a 2.5-page treatment and a 120-page shooting script, we're still okay, Your Honor. I had no idea how it would come out when we concluded. The judge took it under advisement. And then in January of 1990, he issued his first decision, call it Buchwald 1. The judge found, in essence, that Paramount had breached Buchwald's contract. They had made it Coming to America based upon his treatment, based upon his idea, and he found in our favor and dismissed all the other arguments that were not germane. Wow, we won. And the media had a field day with it. I didn't really, frankly, I'm not going to, I always knew this was going to be a landmark case and blah, blah, blah. When you're in the battle, you're just trying to survive. You're trying to keep your head down. And we had prevailed. But we weren't finished yet. I also didn't understand how daunting the challenge was to sue a studio because I'd never sued a studio before. I didn't know any better. I'm a kid from Troy, New York. But I thought there was an injustice. I liked Buchwald. I had represented writers and creators and other kinds of skirmishes. Arthur Miller is a very famous Harvard professor, now teaches at NYU, and he was the ABC legal commentator. And the morning that we won the case, he went on ABC national television and he said that this is quite a victory because, the graveyard of Hollywood is strewn with the skeletons of people who've sued studios and failed. Pretty nice. But, it was a bittersweet victory because Art Buchwald went on TV and told everybody how happy he was and that Pierce O'Donnell was a free lawyer. You know how many phone calls we got at Case-Shiller in the next couple of weeks, letters, telegrams. Everybody wanted that free Irish lawyer out there in LA. I never forgave Buchwald for that. So what have Buchwald 1 wrought? Well, we have a breach of contract. And we're entitled to 19% of the net profits and a couple $100,000 of fixed compensation. So there was going to be a phase 2 for accounting. However, after a month, we got a box full of financial records from Paramount, and guess what? Coming to America had been the second highest grossing movie in the summer of 1988, forgive me, the number one comedy, and it grossed about $350 million at the box office. Rule of thumb, about 50% of that would probably end up over at the studio. And despite having grossed all of that money and a budget of about 60 million bucks, 25 million for prints and advertising, marketing, maybe 80, 85 million dollars, that movie not only was not profitable, it was $19 million in the hole, deficit. It didn't make sense to me until I reread the net profits rider to the contract. There's a separate document. And I saw how they did their math, and I said, wow, that's like stealing at the point of a calculator. Buchwald couldn't understand it. Bernheim was beside himself. We were on a contingency, and we'd already racked up hundreds of thousands of dollars of time and a fair amount of costs. And gross, they accrue for this, and they cash basis for that, and there's interest costs and overhead, and you only get 20% royalty on the video cassettes, not 100%. Of course, that was a big part of the revenue picture even back in the day. And this just didn't make sense. We were sitting in my office in Century City one day, and I had my colleagues sitting around me, and I just said, this is just, I think I used a word before it, unconscionable. It's unconscionable. And one of my bright colleagues, I think Zazie Pope, who went on to be the head of litigation at Warner Brothers, said, yeah, I think there's something in the civil code about unconscionability. I did not take commercial paper at Georgetown. It was not my interest. And so we grabbed the civil code, 1670.5, and sure enough, court has discretion to strike some or all of the provisions of a contract that it finds to be unconscionable. So literally, the four of us raced to the library, read everything we could on unconscionability, and I'll short circuit this. So we brought a motion or whatever challenging the accounting by Paramount as unconscionable. By then, Draper had been replaced by Charles Diamond, fabulous lawyer, became a friend of mine, one of the best trial lawyers I've ever been up against. And the laughter from O'Melveny's offices and the Paramount lot on Melrose was deafening. I think they were preparing civil commitment papers for my team and me. Unconscionable, are you crazy? This is a standard clause in Hollywood. Everybody does it. What do you mean? We need this to survive. And again, I'll short circuit it. That became to me, of the three trials, the most complicated, difficult, legally challenging, factually based, because facts won that battle, I think, after the judge made his legal rulings. And we had a tiger by the tail because we weren't going to get any money except a couple $100,000 unless the judge threw it out. And Paramount decided that it was going to have a broad brush defense. You read the decision, Paramount told the judge right up until a month before the second trial that they had to have the net profit definition the way it was written for the studio to survive. Winners have to pay for losers, they told the judge. And they put in some declaration about all the losers in the last umpteen years, and you have a rare winner like Coming to America, and they need the money they can generate from that onerous net profit definition. I filed a couple of declarations from my accountant saying, well, I don't think that may be not true, Your Honor. I think we need to investigate. And Judge Friedman did a very, very unusual thing. He appointed the senior partner of Price Waterhouse in LA as the court's expert. And he instructed Paramount to deliver a lot of documents for the dozens and dozens and dozens of movies that they had listed as stinkers, and some that I found that were very profitable that they had failed to put on the list. And I'll never forget this. Chuck and I are there at the podium. The judge has the Price Water guy standing there. He's instructing him. And Chuck says, excuse me, Your Honor, Paramount has decided it's going to withdraw its defense that it needs the net profit definition as written in this case and every other case for its economic survival. So the decision that we made to challenge this, what was really a kind of a popular idea, it was an urban legend. You know, only 1 out of 10 movies make money. The studio's lucky if they can get 1 or 2 winners, maybe 3 if you're lucky, really, really lucky, because it just doesn't work for the studio unless they can siphon off a lot of profits from the winners. So we made the decision to challenge it, and bless him, Judge Friedman figured out what we were doing, appointed Price Waterhouse, and Paramount ran away. The judge issued his ruling, I think right around Christmas Eve, during the Paramount Pictures holiday party in December of 1990. And we won. And in what I think is considered a landmark decision, Judge Friedman found that the standard net profit definition used by Paramount and by every one of the other studios was unconscionable. He first found it was a contract of adhesion, take it or leave it. Buchwald got to negotiate a few things, but they were procedural. You get 10 months to audit versus 6 months. Didn't alter the definition in any material way. So he first said, this is an adhesive contract. That means we got to look at it carefully for vestiges of unconscionability. Unconscionability has 2 parts: procedural, were you surprised by the outcome? And substantive unconscionability, is this an unduly harsh or unjust result? Interesting, the judge said, no, I don't think they should be surprised, because everybody gets screwed like this who has a net profit definition, okay? So Bernheim, they had William Morris, they shouldn't have been surprised. But let me tell you something. This contract is onerous, it's oppressive, it's unreasonable, and leads to an unjust result. A movie that makes hundreds of millions of dollars should not generate a loss for the participants, particularly the creators of the movie. And then I had listed 15 features of the net profit contract. Overhead, interest on overhead, 10% advertising surcharge, interest on that, not crediting receipts in order to reduce the deficit before you do this, not taking it went on and on, okay? I had 3 distinguished accountants whose names were Hackerfinger and Knives. I'm not making that up. That were their names. They provided devastatingly helpful forensic accounting and expert opinion in their declarations and in their court testimony, okay? And so the judge went down 7 of them. Unconscionable. And he figuratively in the opinions, he said, I don't have to go any further. This contract is, quote, hopelessly permeated with unconscionability, unquote. Unfortunately, he stopped at 7, and the 8th one was paying only a 20% royalty on video cassettes, which was indefensible. If I put that in the first 7, that might have significantly altered the way accounting is done in Hollywood, and paying only 20% of the gross after deduction of certain expenses. Paramount had some defenses. They said that I couldn't piecemeal what I liked and not liked. I never forget my buddy Chuck Diamond said, Mr. O'Donnell, he's remarkable. In the first phase of this trial, he embraced this contract. He loved this contract. He loved the based upon language. But now he's repudiating the contract. He doesn't like this contract. And in oral argument, I said, well, Your Honor, I like Ralph Waldo Emerson. And he said, a foolish consistency is the hobgoblin of little minds. And I told the story of Lincoln, who argued in the Illinois Supreme Court on a Monday, a certain principle of law in a real estate case. And he came back Thursday, and for another client, argued just the opposite. And one of the justices remarked about the fact this was inconsistent. Can you explain this to us, Mr. Lincoln? And Mr. Lincoln said, I've learned a lot between Monday and Thursday. And I learned a lot about Hollywood accounting. And so we attacked it. The judge ruled that we could attack a part of the contract, that it could be severed, if you will, from the rest. And he found, again, that the contract, as it related to net profits, was unconscionable. Well, if you thought there was a headline on phase one, Paramount misappropriates Buchwald's idea for coming to America, there was a tectonic movement of the plates in Hollywood, because this was shocking and put every single net profit definition up for grabs, because, as the judge found in his opinion, you couldn't go somewhere else to negotiate a better agreement. Buchwald couldn't take his story, Bernheim, take the project to another studio. You'd end up with the same definition, with the same deficit, negative effect. So, wow, there's no contract on compensation. How do I get money? We still didn't have any money. So the judge scheduled discovery and a third phase trial. And that dealt with what is an idea worth. Fascinating battle. At least 6 distinguished writers on our side testifying. By deposition, they had at least 6 distinguished writers and studio executives and all kinds of people basically saying an idea isn't worth spit. And we're saying, well, without an idea, you don't have very much. And I even commented that I think I've heard a rumor that studio executives would like to find a way to make movies without writers. So we put on witnesses. I was pushing the envelope saying, hey, we want millions and millions of dollars. Paramount said, that's not worth anything, but if it is, it's worth about $4.50. The judge was very Solomonic, said I was asking for too much, Paramount was asking for too little. And between fixed compensation for Bernheim, his 17.5 points of net, Buchwald's 1.5 points of net, he awarded, I think with interest, about $1 million. Paramount crowed, hey, Buchwald didn't get $5 million, he got only $1 million in 1992. And Buchwald, ever at the ready, when asked about this, said, not getting $5 million is like a death in the family in Hollywood. Buchwald was very happy. Bernheim was very happy. My firm waived probably $1 million plus of legal fees. They just paid costs. And that's basically the story. Lots of decisions were made. We were constantly under scrutiny by the media. And I have to say something, and my wonderful co-writer from the LA Times, Dennis McDougal, and I made this point. Judge Friedman was a remarkable jurist. He was inscrutable. I couldn't figure him out. Never knew how we were going to come out in any one of the 3 phases. And he did a Columbo on us on phase 2 on the accounting. I want to share that. He sort of somehow, well, what is this? And maybe I need to appoint Price Waterhouse. And when he wrote his opinion, I went and scurried, and I found from a friend that Harvey Friedman graduated magna or summa cum laude from UCLA as a finance major. He got it from day one. And the way he picked apart those 7 elements of the net profit definition was remarkable. Well, all things don't end in the Superior Court. And so Paramount took an appeal. And I think there were 5 amicus briefs on our side and 5 on their side. And it became quite a cause célèbre. And the appeal really was focusing on the finding of unconscionability of the net profit definition. Paramount changed law firms, and O'Melveny was replaced by a firm called Greenberg, Glusker, and by the distinguished entertainment litigator, a guy named Bert Fields. And Bert said he had never lost a trial in his career, and he didn't expect to lose this appeal. That was pretty intimidating. I was about 83 years younger than him. So we took the appeal, and something really unexpected happened. Paramount got a new owner. named Sumner Redstone, a guy I would lock horns with years later in another setting. And he had his lawyers look at the appeal briefs, and he told Bert to settle. So we settled pretty much for the judgment and a little bit of interest, so a little over $1 million. Some of you may know that I joined Greenberg Glusker in 2014, recruited by my dear friend and longtime adversary, Bert Field. So Bert and I are now partners together. What hath Buchwald wrought? What was the significance of the case? Hard to tell. And I think looking back, and there's going to be a question about this, Buchwald and Bernheim were very brave. Bernheim worked in Hollywood and frankly never got a movie after this case. Buchwald didn't care whether you could eat again in this town because he didn't make his living off of Hollywood. So he was brave, but not quite the bravery I think that Bernheim had. We made some important decisions along the way, certainly waiving the jury. Oh, I did something a little sneaky. Draper didn't like it. I took Eddie Murphy's deposition in my conference room at Century City. He came in from New Jersey where he was living. And he entered, da-da, big dramatic entry, but he was nervous. And so I really had two objectives: get the facts from him, but also send a message. So during a break in the deposition, I said to Mr. Murphy, I really appreciate you accommodating us. And I don't know if you know why we take these depositions. No, sir, I've never had this before. I said, well, you see, you live out of state. So when we have this trial, nobody can make you come to California. You can't be forced to come to California, but you've been kind enough to give us this deposition. So, Mr. Murphy, you don't really need to come to the trial. He goes, great. And guess who didn't come to the trial? Eddie Murphy. They sent Arsenio Hall as sort of his surrogate. He had played the prince, his sidekick, in Coming to America. I didn't think he had anything to add to the equation. And I signaled that by having my second-year associate, Zazie Pope from Harvard, cross-examine him. She did a great message, and I think we sent a message to the judge. He didn't even cite Hall's testimony. So I guess the last thing I'd like to say is that the case also had a profound effect on me. It launched my career in Hollywood. I've gone on to represent many talent. I've also defended some studios, not in the same case. I think Bert Field's the only one who has a waiver. He can be suing a studio at the same time he's defending him in another matter. So Buchwald versus Paramount was, to me, a formative case in my career. I fell in love with the entertainment industry. I went on to do many cases, and I actually wrote a screenplay. And after I saw what they did to my screenplay, I never wrote another one. Finally, Buchwald made me make one promise about Fatal Subtraction. I would never option it for a movie to any studio. He was quite adamant about that, clearly adamant. Wouldn't consent to the book being done without that agreement. I said, okay. So let me tell you something, Pierce. If Hollywood ever got a hold of the story of our case, it would end up looking like Bambi. Okay. Questions?
Thank you very much. That was very entertaining and very informative. I hope everyone can hear me. I've seen a couple of comments saying that people are having problems, but apparently they don't have a problem hearing you. So the first question I have is from Michael Hill, and it's this. He says, some legal scholars, incorrectly I believe, have tried to maintain the impact of the Buchwald case on the business practices of Hollywood. You wrote in Fatal Attraction, quotes, Art Buchwald was not Joshua, and the walls of Hollywood are still intact, but it's no longer business as usual either, close quote. Can you elaborate on the impact of the case and how practices in Hollywood, especially for writers, have changed for the better?
Well, first of all, there was a defensive reaction by the studios. The studios all got paranoid about idea submission cases. This was essentially an idea, Disney versus Wilder kind of a situation. Disney was an oral implied contract. This was a written express contract. And so they tightened up their procedures. They logged things more carefully. And it was bad for some writers. The guy who just got off the bus from Iowa, who had a great script or idea, because they didn't take unsolicited manuscripts for a long time. So you had to get an agent or maybe a manager or a lawyer. And so that was kind of a negative impact. I don't know how serious it was or how long-standing. So they tightened up their practices. Net profits. Well, there was a cynical reaction by all but one studio. They just changed the name to kumquats or avocados. They weren't net profits anymore. And somehow they thought that that would magically take care of it. But DreamWorks, Helene Hahn and those good folks over there, they actually wrote a new contract. And they called it contingent compensation. And they spelled it out. They took a lot of the onerous portions of Paramount's contract that had been invalidated by Judge Schneider as unconscionable. And it was very straightforward. If the movie made money, you made money. I think it also led to an emboldening of creative talent and a generation of lawyers that have followed Buchwald who've taken on studios. And there have been some other landmark decisions, Home Improvement, for example, and some copyright cases. But I think that people saw that the system worked. I think the system worked in Buchwald versus Paramount. Were there radical sweeping changes? No, because the studios had the gold and the gold rules. But I think there were some changes. And I think writers felt better. We got a lot of nice comments from writers. They would come up on the street and say, Mr. O'Donnell, Mr. Buchwald, I'm really trying to support you. And Art said, would you give me $10 towards my photocopying costs? And they walked away. So, but.
Okay, I have another question from William Immerman, which is as follows. Do you think calling profit participations, quote, defined proceeds, close quotes, and claiming that they are a negotiated formula escapes the unconscionable formula?
Well, I don't think, no, I understand it. You mean if you say black is white in a contract and we've negotiated black is white, you're immune from a Buchwald kind of challenge? I don't think so. I think people sign things in contracts all the time, waivers when you park your car or whatever. I don't think that would get rid of it. I think that if you were clear about what the impact might be, and that was one of the important things for the judge, that's fine. Look, I know people that don't even want net profits. The screenplay I wrote, which was produced, I refused net profits. I said, I'm not, I got a reputation to deal with, so I didn't take net profits. I thought they were a joke. And even though it was a $4 or $5 million budget, it might have made net profit. So that's pretty cynical to me.
I have another question here from Bob Aronoff, which is as follows. Eddie Murphy is often quoted as saying that net profit points were monkey points. Can you comment on that?
He said in my deposition, I asked him about that. He started laughing. I don't take net profit. Those are monkey points. I said, well, excuse me, what do you mean by monkey? He said, well, when you get your statement, you laugh like a monkey because you're not going to get any money. So that's what he called
them. There's a question from Barry Schreiber, which says, unconscionable versus bad faith.
Okay, I think I might know what that means. The judge, we alleged it was unconscionable. We also had a breach of the covenant of good faith and fair dealing, which would be a bad faith. And when the judge ruled in our favor on unconscionability, he basically said, I don't really have to get to that question, okay? If you don't have an unconscionability analysis, say it didn't exist, I think you could construct a demurrer-proof allegation as a cause of action that it's a breach of the covenant of good faith and fair dealing because they've created obstacles in your path. However, the problem with that argument is if the contract spells out what's supposed to happen, what obstacle do they throw up in your path other than one that you knew about? So it might be problematic. It turned out that the unusual, the unprecedented unconscionability statute is what prevailed. If you think about it as a layperson, not a lawyer, you got a movie that's a blockbuster. Everybody made money off of it. The director, the actor, the studio, the writer, but one guy, the creator and his producer partner. And it took in $350 million and the studio got $150 million. And no matter how much more money came in, the rolling break even killed you. It's like a tumbleweed going across a desert highway. You can't catch it. So we show that no matter how much more money, 400 million, 450 million, whatever additional money came in, because of the effect of overhead, interest on interest, interest on overhead, only 20, whatever it was, you were never going to catch up. And that's unconscionable. It's not fair. It's not reasonable. It's not a fair allocation of risk and reward.
Here's a question from Matthew Horowitz. It sounds like the case wasn't profitable for your firm immediately, having to write down a large portion of the fees. But did the firm thrive in the future as a result of this case? Did the firm see the outcome as a success?
Probably. I was able to recruit a couple of fantastic substantive entertainment partners, transactional partners. We did more fee work, and I certainly launched me into this field and doing a lot of cases. It was the right thing to do. I'd gotten a book contract, and I gave all that money to the firm. $350,000. I guess Dennis got half. So I did that to try to mitigate the loss. I didn't take any money from the book, although I wrote it on my own. Yeah, I think it was a loss leader, if that's the import of the question, probably. But it's also, be careful what you wish for, because it ended up being 3 trials, not 1. And so we had a studio by the tail, and we couldn't let go of it. But I would do it over again and again. It was such a remarkable experience. And, Buchwald, on the wall over here in my house, I have a beautiful color photo, a framed photo of Art Buchwald, Zen, and he wrote to Pierce O'Donnell, my lawyer. He kept me out of prison, and that's sort of, when you're dealing with that guy almost daily and that kind of a humor. For example, when they issued the net profit statement, shocked us in the world that a $350 million movie had a $19 million net loss. Buchwald knew that Paramount had just re-released a color version of Cecil B. DeMille's 10 Commandments. And so when pressed by reporters, what do you make of this net loss after all this movie made all this money? He said, it's a sad day when the studio makes the 10 Commandments diddles its talent. And so I also found out that Paramount had spent hundreds of thousands of dollars to train Chuck Diamond in media relations to deal with Buchwald, and Buchwald didn't have to hire a media trainer.
I think on that note, we're going to wrap it up here. So I want to thank you very much. I know you've worked very hard prepping for this. We appreciate very much your time and all your good efforts on this. And I want to thank everybody else who has joined us today. I also appeal, if anybody has any ideas for any future programs in our War Stories series, if you can think of anyone who would be could follow in Pierce's footsteps, please let me know. And again, thank you, everybody, and particularly Pierce, thank you very much indeed. I think we're done for the day. Goodbye.
Back to Mork and Mindy. Thanks.
Be safe, be healthy.